Honorable the Chief Justice of India, Dr. D.Y. Chandrachud, Honorable Chief Justice of Karnataka, N.V. Anjaria, esteemed High Court judges, conference participants who have traveled from across the world to be here, distinguished guests and enthusiastic students. We are delighted to welcome all of you this morning to the Bangalore International Center for the keynote address of the 11th annual conference titled, Is There Hope for Equality Law?, organized by the National Law School of India, the Berkeley Center for Comparative Equality at the University of California, Berkeley Law School, and the Oxford Human Rights Hub at the University of Oxford. In the last 8 months, colleagues at NLS, BCC, and the Oxford Human Rights Hub have worked together to make this conference possible. Over the last 2 days and later this afternoon, we will have as many as 130 participants presenting papers across 32 panels. For most of you who are in the audience today, you have engaged with intensity in this intellectual exercise, and I trust you will agree with me that it's been a rewarding and promising effort over the last three days. The conference sports a provocative title, Is There Hope for Equality Law? And what we can say at the end of these 2 days and with what is to follow this afternoon, that there is hope, and we have a lot of enthusiasm and optimism in this room. Some of those topics covered include the debates on direct and indirect discrimination, debates on the grounds of discrimination, traditional topics in equality law, as well as new ones like an engagement with climate justice, refugee rights, criminal law and civil liberties, and a theme that emerged through the conference that I at least had not anticipated as strongly is a focus on economic equality, both as a fit topic for an intervention by equality law doctrine, but also a topic that is critical to the future of liberal democracies around the world. So today, I will not try to summarize much else that has occurred over the last 2 days. We are here to listen to the Honorable Chief Justice of India, and I will briefly introduce him, and we agreed that unlike the annual convocations of the National Law School of India, we will keep it brief and get to the main part of our engagement, which is to hear his passionate views on the idea of equality and its journey in India. So briefly, Dr. Justice D.Y. Chandrachud is the Chief Justice of India who took his oath of office on the 9th of November 2022. He was appointed to the Supreme Court in May 2016, but had previously been the Chief Justice of the Allahabad High Court between 2013 and 2016, and a judge of the Bombay High Court for 13 years between 2000 and 2013. Justice Chandrachud joined the Bombay Bar after obtaining LLM and SJD degrees from the Harvard Law School. And during the period that he has been on the Supreme Court, he has focused on at least 3 different areas of deep engagement. Certainly on the judicial side, I think all of us are familiar and aware of his work in the area of equality, the topic of this conference. But going beyond that, he has worked intensely to change the structure and working of the Supreme Court of India, as well as the 18,000 courts that make up the Indian legal system. This effort on the digital transformation of the Indian court system is one that will have great meaning in the decades to come. He has also focused intensely on increasing public access to the materials of the court, its judgments, but across languages and across barriers of ability to make sure that inclusiveness and access in the Indian legal system is one that we change in dramatic and possible ways in the years ahead. So all of this, I think, should suggest to you why we thought that he was the best person to make this keynote His extrajudicial speaking arrangements are always full, and we always have trouble controlling the numbers that we bring into the room. Today was no different. And so with that, may I welcome the Honorable Chief Justice of India, Dr. D.Y. Chandrachud, for his keynote address.
Thank you so much, Professor Krishnaswamy. A very good morning. Professor Sudhir Krishnaswamy, Vice Chancellor, NLSIU, Professor Nigam, the Registrar of NLSIU, my very dear friend, the Chief Justice of the High Court of Karnataka, Justice Anjarya, judges of the Karnataka High Court, chairpersons of the various panels at this conference over the last few days, participants. I see so many friends both from India and overseas, within the faculty and outside. Members of the bar, teaching and non-teaching staff of NLSIU, and my very dear friends, the students. Well, I'm more than delighted to be speaking at this conference of vital contemporary importance. I see the working of equality in the work which we do every day as judges, but also in the processual deficiencies in access to justice, which we are constantly trying to bridge in our courts. When I was invited to speak at this event, I noticed that the theme of the event is framed as a question, an existential one at that. Is there hope for equality of law? The choice of framing the theme of an anti-discrimination and equality law conference as a question on the very existence of equality law seems interesting, disturbing, but full of challenge and opportunity at the same time. There must be a foregone conclusion in the minds of those who settled on the theme of the conference, but I thought that surely the question is also rhetorical. Perhaps it has a lot to do about the way democracies have evolved in the last 30 years. Particularly after market reforms wrought fundamental structural changes in so many societies, including our own. And there's this perception that global trade, market reforms, and liberalization, as we've called it, has surely not trickled down on an even platform to all segments of our societies. Surely no one would believe that equality law is staring at hopelessness. I mean, I'm sure all of us come here with a sense of hope. But the more I look into the question, the more it seems pertinent. Equality is a guarantee which requires us to pay constant premium. We pay this premium by guarding even the slightest erosion of human dignity and equality. After all, the equalities we cherish today were not achieved easily. Recently, I had the opportunity to visit Tashkent in Uzbekistan for the Chief Justice's Conference of the Shanghai Cooperation Organization. In 1978, during an excavation for the building of the Tashkent TV tower, the construction workers unwittingly made a chilling discovery. They had found a mass grave where over 13,000 Uzbeki poets, public intellectuals, leaders, and anyone suspected of dissidence was killed in the 1930s by the Soviet regime after a summary trial. Today, a museum of victims of political repression stands on the same land with a declaration, "May the memory of those who have fallen for freedom live forever." The sobering reminder of people who laid their lives for freedom made me think of how much we take our own freedoms for granted. It made me reflect on how the basic virtues of our society are not guaranteed after all. Among them are the principles of freedom, equality, and democracy. Our cherished freedoms and liberties need constant champions and nourishment. I'm reminded of a quote by the 19th century American abolitionist Wendell Phillips, who said, "Eternal vigilance is the price of liberty. Power is ever stealing from the many to the few." And every day over the last 24 years, I've seen the constant battle of how fundamental freedoms and fundamental constitutional values such as equality are chipped away not even brick by brick, but in infinitely small proportions every time that you come to face with injustice. When we think of freedom, we must ask ourselves a preliminary question. Who is this freedom for? Does the idea of freedom resonate with everyone? Would all people around us admit to being free? I would like to illustrate this using a recent incident. Delhi witnessed an 86-year record-breaking rainfall. To avoid flooding in these circumstances, the drains were being opened and cleaned of all waste which may cause water clogging. Men work every morning to open the drains and pick out buckets full of waste, most of it manually. When they get tired of laboring for hours, they put 2 drain covers together and sleep over it to recover. Normatively, these men have accepted a contract to clean the drains. They have put in work and expect payment for it. However, are these workers truly free? Freedom from having to clean waste manually has a deep and historical context rooted in caste in our society. In this case, freedom is inextricably rooted in the concept of equality. An unequal society implies an unfree society because the lower unequals are always unfree from the higher unequals. Societies all over the world are built on hierarchies which divide people on an arbitrary basis. Discrimination exists on the basis of religion, race, caste, sex, sexual orientation, disability, place of birth, and other grounds. And for so many of the faces that I see in the audience, I know that most of you have championed at least one, or if not multiple grounds of these disabilities and discrimination. Large parts of the population are effaced from the purported mainstream. And the mainstream is populated by a slender portion of the population. At a time when equality and anti-discrimination law claim to be in the mainstream, with the highest number of proponents than at any other time in history, we must ask ourselves why prejudice and discrimination still thrive. The question mark in the theme of this conference and the inquiry of hopelessness is, to put it bluntly, on the nose. But this is quite a vicious trap. Hopelessness, as naturally as it may come to all fair-minded and good-hearted people, is a tool of oppression. We stand today in a world where conversations around anti-discrimination and equality are gaining currency. People, especially the younger generation, are challenging our assumptions and daring us to imagine a more perfect world. The role of law is being reimagined. The historically wielded law which reifies and rigidifies social hierarchies is being replaced by laws to address discrimination, harassment, and victimization. Laws like the Criminal Tribes Act of 1871 and Section 377 of the Indian Penal Code of 1860 have given way to legislation like the Transgender Persons Protection of Rights Act 2019. These developments in the law stand on centuries of activism and work by members of oppressed groups. Members of marginalized communities fought to end ascription based on discrimination. Feminist movements sought to end sex and gender discrimination. Our great freedom fighters fought the scourge of colonialism and subordination. Queer and transgender activists have called into question the fundamental arrangements of our society which create prejudicial structures to begin with against them. Disability rights activists have challenged our models of competence and the evil laden in our moral judgments against the disabled. The sustained efforts of people putting themselves in harm's way to fight the good fight and create a fairer and more equitable world has led to systemic change, and about that there is no doubt. It has changed the way people perceive the relationship between the state and citizens. It has led to constitutions being adopted with equality as their cornerstone and laws being enacted which aim to ameliorate inequities. One of the apt examples of this is, of course, the Constitution of India, which not only prohibits discrimination, but also puts an obligation on the state to end discrimination. But the more we look into the perils which equality law seeks to address, the more we realize that this body of law, more than others, is ever expanding, dynamic, and even turbulent. I shall therefore address this lecture in 4 parts. First, I will talk about the traditional understanding of equality and its manifestation as formal equality. Second, I propose to trace contemporary trends in equality law from a comparative law perspective. Third, I will reflect on some emerging themes in comparative equality law. And in conclusion, I argue that equality is a moral imperative of our times. First, equality is a layered concept which borrows from morality, politics, sociology, and the law. From a legal standpoint, equality produces legal rights and anti-discrimination measures. In other words, law produces both positive and negative aspects of equality. The desire for inclusion of historically excluded groups began by the prohibition of differential treatment of groups on the basis of specific grounds or characteristics. In a judgment of 2021 in Lieutenant Colonel Nitisha versus Union of India, I had the opportunity to trace the trajectory of equality before the law. In the normative and traditional sense, equality is symmetrical. As Aristotle put it, things that are alike should be treated alike. But Aristotle himself had no qualms justifying the ownership of slaves or the subordination of women, because the basic premise in a formal equality paradigm is the like treatment of likes. So it depends on how you define who the likes are. And if the definition of who is alike by the law is itself flawed by systemic discrimination, then your conclusions will be based on a fundamentally distorted paradigm and assumption. Equality in its traditional conception becomes contingent on your equal stature. This stature may be explained away by pointing out banal differences between people and ignoring historical maldistribution of life opportunities. For example, prescribing an exorbitant fee for an examination may be permissible in formal equality because there are no provisions to explicitly bar poor or low-income candidates from applying for the examination. The underlying problem of poverty is brushed aside as a personal failing or responsibility. Similarly, formal equality would accept the requirement of lifting 3 times your body weight to be eligible for a firefighting job. The requirement seems equally applicable to all, but fails to see the disproportionate impact that women would face because of their anatomical differences. A formal equality analysis would argue that the anatomical difference of women is personal, quote unquote, a shortcoming. It is based on natural differences between the sexes and needs no accommodation. So in a recent case which related to the inclusion of women in our armed forces, women in their 50s who are being granted permanent commission in the Army, Navy and Air Force was sought to be compared with their male counterparts in their 20s. And the argument was, this is equality. If they want entry into the armed forces, they better be equal to the men who are going to join the armed forces today. Formal equality prohibits intentional discrimination based on stereotypes or prejudices. The concept can be summarized in the words of the French author Anatole France, who in 1871 had said, I'm sure we've all heard this many, many times without end, that the law in its majestic equality forbids the rich as well as the poor to sleep under bridges, to beg in the streets, and to steal bread. The conception of equality informed the earlier development of the law. In the US, we saw judgments like Plessy v. Ferguson, which espoused the now infamous separate but equal doctrine to uphold segregation. Its underlying logic was that the white and colored population can be segregated. Equality would be ensured till both populations received accommodation. But the ability of the colored population to enter places demarcated for the whites was not guaranteed by the Equal Protection Clause. Similarly, in Washington v. Davis, the US Supreme Court held that a facially neutral qualifying test was not violative of the equal protection guarantee merely because African Americans disproportionately failed the test. In India, we have been using the twin test under Article 14 of the Constitution to test discrimination on the anvil of intelligible differentia and rational nexus. One of the first Supreme Court cases to apply this test was in 1952 in state of West Bengal versus Anwar Ali Sarkar, which dealt with a state law allowing for cases to be referred to special courts at the discretion of the state. The formal conception of equality has been beneficial in some instances. As recently as in 2020, the Supreme Court resolved questions of equality when it saw formal discrimination. In Union of India versus Babita Punia, the Supreme Court was confronted with the issue of granting permanent commission in the army to women who are engaged on short service commissions. Section 12 of the Army Act 1950 stipulated that no female shall be eligible for enrollment or employment in the regular army except as the government may notify. The court held that an absolute bar on women seeking criteria or command appointments was impermissible under Article 14. Formal equality has helped society find a vocabulary against discrimination and prejudice. But it is premised on the belief that all institutions inherently treat individuals fairly and that discrimination can be ameliorated by removing formal barriers. This stage in the development of equality law helped remove explicit barriers and achieve significant milestones like the right of women to vote and ending employment discrimination. Formal equality has been helpful to a limited extent. It has removed the assumption that inequality is natural or desirable. It has helped in removing overt discrimination. It has also allowed marginalized communities to find a language to verbalize their experiences and develop the idea of equality itself in a substantive sense. As a judge of a constitutional court for the last 24 years, I've often dealt with cases that have compelled the court to unravel multiple dimensions of equality law. And in the second segment, I'd like to briefly dwell on the contemporary trends in equality law. In such situations, I ask myself several questions. I want to discuss two of these questions today. The first question is theoretical. How should the court ground its understanding of inequality beyond a formal or ascriptive understanding? Should the court also recognize indirect forms of discrimination or limit itself to direct and apparent forms of discrimination? Second, what sources of law should the court rely upon? Should the court borrow from comparative jurisprudence and academic work or restrict itself to the text of the Constitution and existing legal precedent? On the first question of finding a suitable theoretical underpinning, I want to talk a little bit about Iris Young's groundbreaking work, 5 Faces of Oppression, a piece of writing in the 1990s that I read back when I was a young lawyer. The simple yet nuanced framework that Young postulated back in 1990 was in many ways perceptive and far-sighted. The framework has stayed with me and always acts as a compass when I adjudicate cases that require an understanding of equality and discrimination in their substantive sense. Iris Young identifies 5 distinct forms of faces of oppression that marginalized groups are subjected to. The first phase is exploitation, where the labor of one group benefits another, often perpetuating economic and social inequality. These could be visible forms of labor that marginalized groups provide to the more privileged groups of our society. However, this phase of oppression could also include less visible forms of labor, such as emotional labor, where marginalized groups or segments are expected to manage the emotions and needs of more privileged groups, such as women being expected to perform caregiving, and nurturing roles. The second phase is marginalization, where certain groups are excluded from social, economic, and political participation, rendering themselves powerless and invisible. This phase of oppression is particularly insidious as it denies individuals their agency. For instance, the prevalence of sexual harassment of women in the workplace is not only a form of direct violence, but is also an affront to the fundamental rights of a woman to equality under Articles 14 and 15 and a right to live with dignity under Article 21. The carrot and stick policy, often adopted to subvert the dignity of a woman who is aggrieved by unfair treatment at her workplace, results in the exclusion of women from social and professional participation. The third phase is powerlessness, where individuals lack autonomy and decision-making power, forcing them to rely on others for their well-being. This phase of oppression is particularly damaging as it erodes self-esteem and perpetuates dependency. It is to counter such powerlessness that our constitution envisages self-governance models, such as the Panchayati Raj system, and also provides for affirmative action within these models. By empowering marginalized communities to govern themselves, we can break the cycle of dependency and foster a sense of agency and self-determination. This in turn enables individuals to advocate for their own rights and interests, ultimately leading to a more equitable society. In a sense, self-governance and securing political rights cannot be seen as disjunct from equality law, but instead is an integral part of securing substantive equality. The fourth phase is cultural imperialism, where the dominant culture suppresses and devalues the identities of marginalized communities. This phase of oppression is pernicious as it denies individuals their right to self-expression and dignity. Recently, I had occasion of authoring a judgment, Nipun Malhotra versus Sony Picture Films. The Supreme Court recognized the disproportionate impact of disparaging humor on persons with disability in the context of films and other creative expression. The court noted that it is imperative to distinguish disabling humor that demeans and disparages persons with disability from disability humor, which challenges conventional wisdom about disability. While disability humor attempts to better understand and explain disability, disabling humor denigrates it. This dominant narrative in mainstream cinema of mocking disability for a few laughs and as a result devaluing the identity of persons with disabilities is a classic example of oppression through cultural imperialism. The fifth and final phase postulated by Iris Young is violence, where marginalized groups face physical harm, intimidation, and terror. For instance, as I noted in my judgment in Navtej Singh Johar versus Union of India, persons belonging to the LGBTQ plus community are subjected to appalling forms of violence. This violence can take many forms, such as forced marriages, honor killing, and emotional abuse. It is often perpetrated by those in charge of a person's care and support, family members, community leaders, and even the state. I can't tell you how many times in a week or a month we come across cases where it's seeking a writ of habeas corpus against a same-sex partner who's been detained by parents and then subject to so-called psychological counseling. The severity of this phase of oppression cannot be overstated, and it strikes at the very core of a person's existence and physical safety. Apart from recognizing the multiple manifestations of oppression and inequality, another theoretical nuance that we must keep in mind as judges, lawyers, and academics is that inequality may often take the form of indirect discrimination. Such indirect discrimination is linked to a facially neutral provision of law that causes a particular disadvantage to a certain group. For example, a law that disallows one community from doing a particular act but permits another community to do it would amount to direct discrimination. But a law that bars both communities from availing of a certain benefit yet has a disproportionate impact on only one of the two communities because of its unique characteristics would amount to indirect discrimination. The concept is best explained by Hugh Collins in Tarunab Khaitan by drawing an analogy with Aesop's fable about the fox and the stork. It was when I read this article that I realized that my mother had told me this story as a young child when I refused to eat what was being dished out in my plate, times innumerable. The story is about the fox who invited the stork for a meal. As a practical joke, the fox served soup in a shallow dish, which the fox could lap up easily. But the stork could only wet the end of her long bill on the plate and departed still hungry. Then the stork invited the fox for a return visit and served soup in a long-necked jar with a narrow mouth into which the fox could not insert his snout. The story advances the idea that without having regard for the unique needs of others. Everyone may not get fair or equal opportunities in life. Though formally giving each animal an equal opportunity to enjoy the dinner, in practice, the vessels for the serving of the soup inevitably excluded the guest on account of their particular characteristics. In Lieutenant Colonel Nitisha versus Union of India, which I mentioned just a few minutes ago, the Supreme Court analyzed evaluation criteria set by the army, which were facially neutral for all, but they disproportionately impacted women officers. In this context, our judgment recognized the concept of indirect discrimination. I benefited profoundly from Sandra Friedman's formulation of the aim of anti-discrimination law being fourfold. First, it aims to break the cycle of disadvantage associated with status or outgroups. Second, it aims to promote respect for dignity and worth, thereby redressing stigma, stereotyping, humiliation, and violence because of membership of an identity group. Third, it should not exact conformity as a price of equality. Instead, it should accommodate differences and aim to achieve structural change. Finally, substantive equality should facilitate full participation in society, both socially and politically. Another concept that is central to my understanding of equality and anti-discrimination law is intersectionality, often attributed to Kimberly Crenshaw. The term refers to the intersecting vectors of social identities and the multiple forms of aggravated oppression that individuals face due to their intersecting identities. Amartya Sen said this in a book several decades ago when he spoke of the numerous identities which each of us carry. And therefore, discrimination against any one of those identities intersects with all the other identities which define our existence as human beings. In the Indian context, intersectionality acknowledges that individuals belong to multiple social categories, such as caste, class, gender, religion, ability, and sexuality, which intersect to produce unique experiences of discrimination and marginalization. For instance, a woman belonging to an oppressed caste not only faces caste-based oppression, but also gender-based violence and marginalization, which are exacerbated by her intersecting identities. By considering inequality through a single-axis lens, we risk overlooking the complex experiences of individuals with multiple marginalized identities and inadvertently prioritize the voices of the more privileged within marginalized groups. It is also instructive to look at the concept of graded inequality, which Dr. B.R. Ambedkar formulated in his last days in a multi-volume historical account titled Revolution and Counter-Revolution in Ancient India. He argued that the caste system imposes a complex regime of antagonism between castes while promoting partial cooperation between them. Dr. Ambedkar illustrated that under the stable and inegalitarian system of graded inequality, each caste has another community to freely and legally exploit. Only those who were treated as untouchables did not have another caste to look down upon. Here, patriarchy allowed men from the Avarna caste to oppress women in their families. He understood graded inequality to be a system in which all castes and genders are kept in place by having the burden of their inequality compensated by the benefits of exploiting their subordinates. All groups get to share in the spoils of casteism, with Dalit women at the bottom of the hierarchy. In Patan Jamal Wali versus the state of Andhra Pradesh, a judgment of 2021, the Supreme Court was faced with the unfortunate situation of the rape of a visually challenged girl belonging to a scheduled caste. I found it imperative to use an intersectional lens to evaluate how multiple sources of oppression operate cumulatively to produce a specific experience of subordination for a blind scheduled caste woman. To highlight this, the judgment borrows from Kimberly Crenshaw's postulation of the intersectional nature of gender violence, where she states that the singular focus on rape as a manifestation of male power over female sexuality tends to eclipse the use of rape as a weapon of racial terror. In this way, While adjudicating cases and crafting judgments, I try and first identify a sound theoretical framework before jumping on the bandwagon of constitutional provisions, statutes, and precedents. The second issue that I often think about while dealing about my judgments, while ideating about my judgments, is the sources of law that we can borrow from while determining questions of inequality and discrimination. Should the court restrict itself to the text of the fundamental rights in the Constitution and legal precedent? Should the court also rely on academic work? And of course, the most pressing question of how the court should deal with foreign precedent and apply comparative law. As Sandra Fredman has argued in her piece, Foreign Fads or Fashions, the role of comparativism in human rights law, comparative law can be a double-edged sword. On the one hand, it offers a valuable opportunity for cross-pollination of ideas, enabling us to learn from diverse experiences and approaches globally. By comparing different legal systems and practices, we as judges can identify innovative solutions, challenge our assumptions, and develop more effective strategies for realizing human rights. On the other hand, she cautions that comparativism can also perpetuate cultural imperialism, imposing dominant Western values on non-Western societies and disregarding the agency and context of local communities. She astutely observes that comparativism can even be used to legitimize existing power structures rather than challenging them. I wholeheartedly endorse the approach of contextual comparativism in comparative law. This approach acknowledges the intricate interplay between global and local factors, recognizing the diversity of human rights experiences and the need for nuanced and context-specific solutions. By embracing contextual comparativism, we can harness the power of comparative analysis to advance human rights globally while avoiding the pitfalls of cultural insensitivity and imperialism. In my own experience, relying on foreign jurisprudence has been invaluable, particularly in cases where Indian precedents were insufficient. For instance, in the landmark Puttaswamy case, international jurisprudence helped the court establish the fundamental right to privacy in the Indian context. Similarly, in the Lieutenant Colonel Nitisha judgment that I alluded to earlier, recognizing indirect discrimination in other jurisdictions, such as the United States, the UK, South Africa, and Canada, was crucial in shaping our understanding of equality. By embracing contextual comparatism, we can foster a rich and inclusive dialogue between legal systems, ultimately strengthening our collective pursuit of equality. To answer the theme of the conference, is there hope for equality law? Yes, there most definitely is hope, and this eternal hope is found in the dialogue between different legal systems and between academia and the bench, and perhaps dialogues between extreme ends in a very polarized debate that we find in our societies. So what are the emerging themes in equality law? And that's what I really propose to explore in the third part of my presentation. It is important to address the profound intersection of climate change and legal principles of equality. Climate change represents a profound challenge, manifesting as long-term shifts in temperature and weather patterns that affect all of us. However, its impacts are unevenly distributed, varying significantly based on geographical location, socioeconomic status, and individual circumstances. For instance, in South Asia, affluent urban residents may experience climate change differently than those living in vulnerable rural areas. In India, the disparities are starkly evident. Residents in upscale neighborhoods of cities like Mumbai may face flooding or extreme heat differently than those in impoverished coastal villages. Wealthier individuals often have the means to invest in protective infrastructure and cooling systems, whereas poorer communities lack such resources, making them more vulnerable to climate-related disasters. Similarly, in Bangladesh, rising sea levels severely impact low-income communities in flood-prone areas, while wealthier urban residents can afford more robust defenses. This disparity highlights the urgent need for equitable climate policies that address these diverse impacts across different populations. Climate change exacerbates the inequities faced by marginalized and disadvantaged groups. The Intergovernmental Panel on Climate Change highlights this, noting that the impacts of warming beyond 1.5 degrees Celsius and our current mitigation actions to reduce warming fall disproportionately on the poor and the vulnerable. I recently authored a judgment in M.K. Ranjit Singh versus Union of India, where we are dealing with the preservation of the great Indian bustard and the balance between India's commitment to solar energy, which acknowledged that the adverse effects of climate change infringe upon fundamental rights such as the right to life, equality, and a clean environment under Indian law. The ruling emphasized that these rights must be understood in the context of both national and international climate commitments, as well as prevailing scientific consensus. The judgment asserts the right to be protected from climate change's detrimental effects, while also balancing this right with related issues such as displacement and socioeconomic rights. Furthermore, climate change amplifies existing inequalities, turning it into a human rights issue, which particularly affects those whose rights are already compromised. Women, children, disabled, and indigenous people face heightened risks from climate change, including displacement, health inequity, and food security. Inequality thus becomes both a cause and consequence of climate change. India in particular faces profound challenges due to climate change, which has exacerbated issues such as extreme heat, deteriorating air quality, and increased frequency of climate-related disasters. For instance, the rise in extreme heat events, and we saw it in Delhi this summer, is not just a matter of discomfort. It significantly impacts public health, particularly among vulnerable populations such as the elderly and those with pre-existing health conditions. Additionally, the increased frequency of cyclones and flooding affects food and water security, with the poorest communities often bearing the brunt of these disasters. Women who are disproportionately responsible for household tasks like water collection and food preparation are especially vulnerable. As these climate impacts worsen, they also exacerbate existing social inequalities, making it increasingly difficult for marginalized communities to cope and adapt. Gender inequality, in its intersecting forms, has been identified as both a pre-existing condition and a factor enhancing climate change impacts. States are obligated to address such inequality as part of their human rights commitments, and the interaction between pre-existing inequalities and climate change further violates these obligations. This understanding highlights the dual nature of inequality in climate contexts as both a contributing factor and a consequence as well. Despite the recognized benefits of intersectional analysis, I feel it remains underutilized in climate change studies. Often, gender issues are approached in a simplistic male versus female framework, overlooking the complex interplay of power and social dynamics. A more critical intersectional perspective would provide a deeper understanding of how climate change affects different groups, revealing the nuanced ways in which existing social and political relations shape and are shaped by environmental change. This approach could uncover agency and emancipatory pathways, offering more effective and equitable strategies for adaptation and resilience. To illustrate the profound impact of climate change on marginalized communities, I would like to draw an analogy from the Parable of the Sower by Octavia Butler. In this dystopian novel, the protagonist, Lauren, navigates a world ravaged by climate change, economic instability, and social collapse. One scene describes a community struggling to survive amidst extreme weather events and resource scarcity. The characters' experiences highlight how the most vulnerable, those already marginalized by society, face the harshest consequences of environmental degradation. This portrayal highlights the importance of addressing both the immediate and systemic effects of climate change through inclusive and equitable policies. Just as Lauren's journey reflects the need for resilience and adaptability in the face of overwhelming challenges, our legal and policy frameworks must strive to mitigate the compounded impacts of climate change on the most affected of our communities. Ensuring climate justice requires recognizing these differential impacts and actively involving affected communities in decision-making processes. Such a participatory approach can foster more effective and equitable climate policies that truly reflect the needs and experiences of those who are the most impacted. Another aspect on which equality law has intersected is in the use of AI and technology law. For instance, AI-powered diagnostic tools can analyze medical images with remarkable accuracy, assisting doctors in detecting diseases at earlier stages. But technology can also be misused, providing novel and powerful tools for manipulative, exploitative, and social control practices. Facial recognition technology is being increasingly utilized by law enforcement agencies worldwide to identify suspects from surveillance footage, proving instrumental in criminal investigation. For example, the European Court of Human Rights ruled in Glukin versus Russia that Russia's use of facial recognition technology to arrest a protester on a Moscow subway violated the individual's human rights. The court highlighted a violation of Article 8, the right to respect for private life, and Article 10, freedom of expression of the European Convention on Human Rights. This ruling emphasized that the use of FRT in this case was incompatible with the principles of a democratic society governed by the rule of law, highlighting international concerns about its misuse. In the United States, a recent court ruling in the case of the state of New Jersey versus Francisco Arteaga recognized the need for due process in cases involving facial recognition technology. The court emphasizes that defendants must have access to the raw materials used by the police for identification and should be able to test their reliability to build a defense. The ruling highlights the importance of transparency and fairness in FRT in legal proceedings. Studies have consistently shown that FRT algorithms are not always reliable and tend to have higher error rates when dealing with faces of people of color and people who are trans or non-binary. This raises significant concerns about the potential for misidentification and miscarriages of justice. When dealing with AI systems, we must ask where the data originates from and what biases it might harbor. Understanding the sources of our data is paramount in using AI systems that are fair and inclusive. Indirect discrimination can arise from seemingly neutral policies or algorithms that disproportionately affect specific groups, undermining their rights and protections. It manifests at two crucial stages. First, during the training phase, incomplete or inaccurate data may lead to biased outcomes. Second, discrimination may occur during data processing, particularly within opaque black box algorithms that obscure the decision-making process from human developers. The garbage in, garbage out principle encapsulates the idea that the quality of decisions produced by AI systems is only as good as the quality of the data they are trained on. If flawed or biased data is inputted into the system, the outcomes generated are likely to be biased and flawed as well. For instance, predictive policing algorithms often operate as black boxes, meaning their internal workings are not transparent. If historical crime data used to train these algorithms reflect biases or systemic inequalities in the criminal justice system, the algorithms may perpetuate these biases by targeting the same neighborhoods as high-risk areas for future crime. I shudder to think whether I should be guided in a bail application on what AI tells me as the likelihood of the offender repeating the crime. This can result in disproportionate surveillance and policing of already marginalized communities, exacerbating social inequality and perpetuating cycles of discrimination. To effectively navigate the challenges posed by AI in diverse contexts like India, the principle of contextualization becomes paramount. As articulated by Professor Urs Gasser in his seminal book, which is titled Guardrails, Guiding Human Decisions in the Age of AI, contextualization emphasizes the importance of understanding and adapting to the specific social, cultural, and institutional contexts in which AI systems operate. India's rich demographic patterns, characterized by linguistic diversity, regional variations, and cultural nuances, present a unique set of challenges and opportunities for AI deployment. As responsible users, we must ask ourselves these critical questions to ensure that our engagement with AI is ethical and equitable. We need to be vigilant about the origins of data and its potential biases, scrutinize the algorithms we employ for transparency and fairness, and actively seek to mitigate any unintended discriminatory effects. This brings us to the broader need to evolve our current patterns in equality law jurisprudence to address contemporary challenges including AI, climate change, global migration, and other pressing issues. First, transparency is the key. We must ensure that how technologies and policies are developed and implemented is clear and accessible. Transparent systems and processes promote accountability and prevent misuse, aligning innovations with societal values and legal standards. Second, inclusion or inclusivity is essential. Our legal frameworks should be designed to protect and represent marginalized and vulnerable groups effectively. This involves crafting laws and policies that address their specific challenges, actively involving these communities in the decision-making process to ensure that their needs are met. Thirdly, like I just mentioned, contextualization is crucial. Legal responses to contemporary issues must be tailored to fit the unique social, cultural, and institutional contexts of different populations. For instance, laws addressing climate change or technology should be adapted to reflect the diverse needs and circumstances of various communities. Lastly, adopting an interdisciplinary approach is necessary. To effectively address complex issues, we need to integrate insights from multiple fields, including law, technology, environmental science, and social justice. Just a word before I spend about 2 minutes on my conclusion. We have to also rethink institutional design, particularly from the equality perspective and the access perspective. And much of the work which we have done in the last several years in the Supreme Court of India on incorporating or using technology to redesign the contours of the institutional perspectives of the Supreme Court, I believe are crucial. Whether it's in terms of digitizing the Supreme Court reports to make a free digitized copy of the Supreme Court reports available to every citizen in India or globally, whether it's in terms of live streaming court proceedings, whether it's in terms of providing a permanent transcript of oral arguments simultaneously by converting speech into text, whether it's in terms of translating our judgments into every Indian languages recognized by the Indian Constitution, I believe that technology has a huge source of potential in redesigning institutions and in creating a new institutional design which would, in that sense, be more equal, because our processes can be as exclusionary as the substantive outcomes. And all too often in courts you see that it is the inequality of the process which is itself tailor-made to generate substantive outcomes which are unequal. So the first step towards achieving more substantive equality in terms of outcomes is also to create a process which is built in to accommodate differences, processes which are built in to recognize differences, processes which are inherently more inclusive and accommodating of plural identities which define a nation like ours. And I believe that stressing on these processes in institutional design as much as substantive outcomes is key to producing a more equality jurisprudence. In conclusion then, I would like to draw your attention to two crucial questions. Why should we seek equality? And from what vantage point should we look at removing prejudicial barriers? The history of equality law and its contemporary manifestations have seen many justifications for wanting an equal world. But fundamentally, we should seek a world without discrimination and prejudice, not only because it is net beneficial for any society, but because it is the right thing to do. There is a moral imperative in this simple but radical idea that all persons are equal and deserve equal opportunities and life chances. We must seek equality to meet our moral obligation and imagine a more egalitarian world. To this end, our outlook towards equality and anti-discrimination has unfortunately been from a perpetrator perspective. This means that most of our equality and anti-discrimination law initiatives are aimed at redressing harm once it has been committed against a marginalized person or group. I argue that we must eschew from solely focus on harm, which is already done, and focus on building structures and systems which do not perpetuate hierarchy and prejudice. And therefore, the role of institutions is crucial in ensuring that we build institutions for the future which first recognize that our processes and institutions are replete with dangers for equality. And then we try and replicate procedures which are less unequal. I began this lecture by pointing out that in a formal equality paradigm, all institutions are assumed to be inherently fair and only require removal of formal barriers to entry. However, how could institutions built in a hierarchy-ridden world be so unquestionably egalitarian? Obviously, they are not. Our systems are a creature of our creation and reflect our social realities. The focus of equality and anti-discrimination law must now be to adopt a new role in different circumstances. As we look to a future fraught with climate change disasters and the use of technology, let's commit to creating equitable structures to address these issues at the outset. Equality is a moral, political, and legal virtue. It holds all our social commitments together. As the Scottish feminist thinker of the 19th century, Frances Wright said, "Equality is the soul of liberty. There is, in fact, no liberty without it." I hope that we walk from this conference with a renewed energy to advance new frontiers of equality and anti-discrimination. Thank you very much. Thank you.
So atypical of address by the Honorable Chief Justice, we actually have the opportunity of a Q&A. I'm going to request any member of the audience who chooses to ask a question to identify themselves and to keep their question short and brief. As you understand that this is a public event, questions related to the court and to the decisions of the court or individual disputes may be left aside. All other questions are welcome. We can start. I have a couple of student colleagues who have mics with them. So yes, if you can put your hands up and I can, yes, please.
Thank you so much. Seldom does one get a chance to ask the CJI questions. We seem to live in a society where one acts first and seeks forgiveness later. This has become particularly true for public authorities acting in a politically motivated manner by detaining activists, academics, journalists, and even politicians, for that matter, chief ministers of opposition parties. All of these actions are taken by deep trust in the face that justice will be slow to come. What can the Supreme Court do suo motu to deter this behavior which has become commonplace? As an individual, one is helpless. Your thoughts would be appreciated.
Well, thank you very much for that question. I'll not answer the premise because obviously the premise is what the question is all about. But I'll answer the question. Over the last several months and in fact several years, this is something which we have been emphasizing right from the outset, which is that if liberty has to have a value, one, there have to be two fundamental principles. One, a day in excess of what a person needs to be detained is a day too many. But more significantly, the interface of common citizens lies first and foremost at the lowest levels of the legal system. Because by the time cases reach the Supreme Court, they have to travel through the maze of legal procedures.
increasingly what's happening is that we see that a lot in the Supreme Court, and not just in these highly politicized and big ticket cases that you referred to, but in simple cases where you see an accused who's been charged with, say, possession of a commercial quantity of cocaine, or someone who has been charged with something, maybe even an offense involving assault. People who should be getting bail in the trial courts are not getting bail in the trial courts, as a result of which they have to increasingly move the high courts. People who should be getting bail in the high courts do not necessarily get bail in the high courts, as a result of which they have to move the Supreme Court. Now, this delay, as you rightly say, this delay compounds the problem of those who are facing arbitrary arrests. We have been constantly trying to say that, well, part of the reason for this is the inherent distrust which we have placed in institutions within the country. And I think it's important that we learn to trust people who, maybe in a hierarchical legal system, lie much below, say, the apex institutions, whether in the state or in the Union of India, which is our trial courts. And we have to encourage trial courts to be more receptive to the needs for accommodating concerns of people who are seeking liberty. Unfortunately, the problem today is this, that we look at any grant of relief by trial judges with a degree of suspicion. That means that trial judges increasingly are playing it safe, not granting bail in on important issues or very serious crimes. Now, as we know as judges, just labeling a crime as serious is not an end in itself. At the end of the day, as judges, you have to look at the nitty-gritties of each case and see the fine print in the case. You have to have a sense of robust common sense when you look at a case. For instance, you have an accused in narcotics case. You have to look at the fine points of the case. What was he doing? Was he a cleaner in the truck? Was he a driver in the truck? Was he the owner of the truck? Was he the person who is really the main person behind the trade which is taking place? Now, unless we therefore separate the grain from the chaff in criminal jurisprudence, it's very unlikely that we'll have just solutions. And to allow for decision makers to separate the grain from the chaff, it's important that we also place a great deal of trust. Now, trust doesn't mean that you don't criticize inaccuracies or incorrect outcomes. Obviously, an incorrect outcome is capable of correction at a higher level. But we cannot begin with a premise of distrust. Because if you begin with a premise of distrust, you're going to therefore have a system where the system itself is inherently, placing more and more importance on the highest levels of decision-making within the legal system, namely the Supreme Court, to give relief. And I think that's my concern, that you can't render courts as in the hierarchy as you go up dysfunctional just by the number of very small cases that are placed before us. You'd be surprised at the number of bail applications which every judge of the Supreme Court has to deal week on an end. Most of those cases shouldn't be coming to the Supreme Court at all. We have prioritized bail even during the vacations for the simple reason that these people really at least must have their day in court. Whether they should be given bail in a particular case or not, is for the judge to decide ultimately. But the reason why we are prioritizing bail is just to send this message across to the nation that those at the most incipient levels of the decision-making process have to do their duties, and do their duties without this feeling that I'll be distrusted or that my career would be on the line if I were to decide in a particular way.
Yes. Yes, please.
Good morning, sir. It's really a pleasure to ask you this question. Continuing from a different side regarding the criminal justice system, as you had just rightly pointed out, most litigants come in contact with the lower judiciary in case of criminal law, the sessions courts. And the approach taken by a criminal justice system seems to be centered around the accused and not around the victims of criminal acts. And what that seems to do is, especially with regards to marginalized sections like women and other marginalized communities, poor people, and so on, it seems that people don't want to approach the courts because they don't think that they have any voice in the criminal justice system. It is the state versus the accused, where the victim does not seem to have any role to play, which kind of disincentivizes victims of criminal assault, like rape victims and so on and so forth, to actually approach the court. So what can be done in order to make that more democratic?
Well, you know, your premise that people don't approach the courts may not be entirely correct, because one of the problems which we have is because just the large backlog that we face is reflective of the number of cases which come to the court. But your question was in the context of the victim's rights. Now, you know, there are provisions of our, the erstwhile Code of Criminal Procedure, and obviously positions which mirror that even now, which do recognize the important role which victims have to play. And I do believe that, you know, part of the training which we impart to judges, and we now have judicial academies all over the country. More and more judges are now coming out of the 5-year law course. So judges who have, you know, dealt with an integrated course of law, but more important, judges who are now going to judicial academies where they have a multidisciplinary approach to the law and training in the law. Some states for almost 2 years, where judges are also taught, you know, the diverse perspectives which they must bear in mind, and not, for instance, as you rightly said, not have only an approach to jurisprudence which is centered around the accused. Equally, you must necessarily look at the victim. I spoke about the approach to a victim-centered analysis, particularly in context of intersectionality, which I referred to in my judgment in Patan Jamal Wali, particularly from this point of view, that ultimately, you know, judging is so much about theory, but it's all about creating the crime scene in your own mind's eye. The first thing that all of us as judges try and do when you look at a criminal case, whether it's in appeal or even at the incipient level when you're looking at whether to grant bail, is to create an image of what possibly must have happened. And that image which you create of what possibly has happened obviously becomes more accurate as you have evidentiary records before you. But even at the initial stage, you try and create a picture of what possibly would have happened as between the accused, as between the victim. What is the impact of this particular crime on society at large? And these are the distinctions which I guess every judge tries to bring about. Is this essentially an individual crime, however ferocious? Is this really an individual crime which is unlikely to be repeated in future? Or is this something which is more systemic, in which case you need to protect society or the victim of the crime from the perpetrator of the crime? So this is something which is part of the human process of judging, which in that sense lies beyond you know, just theory about justicing. And it's important that we train judges and devote more resources, more investment in terms of training judges on these nuances of the law, and not just on the broad principles of formulations of the law.
Okay. Yes, please. And I can just request you to identify yourself, because you didn't, the last speaker. Yes.
Hi, I'm Malhar. I'm a 4th-year law student at NLS, and I also co-convene the Legal Services Clinic at NLS. My question is essentially about clinical legal education. And I was just wondering on a conceptual level as to what your thoughts are about how we make targeted interventions as students in pro bono legal aid. Now, we have been doing legal aid initiatives which involve groundwork and working with inmates. But I was wondering what is the right approach according to you, whether it is sort of assisting in mega lok adalats where a lot of pro bono cases get settled on the spot, or whether it's going out on a limb and working individually with inmates and making targeted interventions. Because that is something we're sort of charting out a trajectory for this year. And I was just wondering, your Supreme Court Legal Services Committee also, the mandate is pro bono legal aid. So how can we help and how can we be involved in pro bono legal aid at the Supreme Court level and at the ground level also? So your thoughts would be appreciated.
You know, at the Supreme Court, we have set up the Center for Research and Planning, something which is not widely known, which is a sort of a policy think tank within the Supreme Court. And we have brought a cohort of about more than 25 or 30 young lawyers into the Center for Research and Planning, and we are looking at different aspects, including prison reforms, legal education. One of the areas I thought I must mention is that we are working on is the status of legal aid through law schools and legal aid clinics in law schools. What is the quality? Obviously, the quality varies across India. But what are the learning lessons that we derive from legal aid clinics in the law schools? That report is ready, and that report is going to be published very soon. I'm sure we'll have lots of experiential learnings from that. On the second part of your question, which is what should the role of legal aid clinics should be? What role should they have? Should that role be at the level of the Lok Adalats, or should that role be at a much anterior stage? My own perception is it has to be at a much anterior stage. Lok Adalats are valuable because you attend to large volumes of cases. But Lok Adalats are obviously held at periodic intervals. The intervention which is required by legal aid clinics is on a daily basis. And I therefore feel that the legal aid clinics must replicate more or less the paralegal volunteer scheme which has been propounded by the National Legal Services Authority, by getting students to consistently visit jails, consistently find data. I'll give you just one example. We get repeatedly cases under Article 32 of the Constitution, which is our original jurisdiction for those who are from overseas. Now, those cases are of convicts who have been convicted, say, even of a serious offense like multiple murders, who have lost all the way to the Supreme Court, but who have now crossed that point in their sentence where they don't need to be kept in custody anymore. Repeatedly, we have cases where convicts are in jail for 25 years, 30 years. They are the most under-resourced of convicts in our jails. We have delivered judgments looking at remission policies of states like the state of Uttar Pradesh or the state of Madhya Pradesh. And we have said that there should be no reason for a convict to themselves apply for remission. This must be as a matter of right. The point of time at which a convict really is entitled to remission of sentence or premature release must be evaluated and dealt with in the jail, irrespective of whether the person has the knowledge that that facility is available to them. We have asked several state governments now to have portals so that this can be assessed. Yet we find week on week cases coming now in the exercise of the contempt jurisdiction telling us, please exercise your contempt powers, because despite your judgments, I have not been released. My application for the grant of premature release has not been considered. That's where I think the intervention by legal aid clinics within the law schools would be extremely valuable, because we could perhaps we have focused on the involvement of students with the higher judiciary, with the Supreme Court. We have our law clerks. The High Court judges have their law clerks. I think it's important that we now think of associating not just legal aid clinics, but law students on a more systemic basis with the work of the district judiciary. Because, together with the district judges, law clerks can be, in that sense, drawn from the law school, can be extended arms of the district courts. Our district courts are intended to do that function, but obviously district judges are overwhelmed with the kind of work which they have to do and multifarious responsibilities. So if this work can be done by a district judge, say in collaboration with, say, a dozen law clerks in that particular district, depending upon the size of the district, we'd be able to deal with systemic issues, particularly in the context of prison administration, which otherwise rarely come to the fore, except when sporadically they are brought before the highest court of the land. But the importance is, I think the important thing is to institutionalize this process by having a collaboration between law schools and the district administration in the judiciary. Of course, there have been some amazing examples. For instance, Project 39 of the National Law School of India, Delhi, where they've intervened in cases involving convicts who've been sentenced to death, has been remarkable. I have presided over several cases where not only has the death penalty been remitted to imprisonment for life, but you find cases where the convict has been acquitted while facing the death penalty, just because of the involvement of the academia in the process of the court.
We take one last question. Yes, you had your hand up, right up. Yes, please. In the interest of having members of the public, please.
Yeah, my name is Hari Hegde. Thank you very much for your lecture. I'm neither a lawyer, so it's a common man's question. You did touch upon the role of court and judges in ensuring equality and hence justice, and also responding to earlier two questions. I heard you mention common sense, human process of judging. My question is, should courts go beyond the legal framework that is available for them in case it's critical that the substantive outcome is true to the idea of equality and justice?
That's an amazing question. It's very, it's a question which we could probably spend the next half an hour on discussing, and I'm sure we'll have different people in the audience with different perceptions. Let me tell you that there are different layers to judging. There are aspects to judging which are dependent crucially on the evidentiary record, where you don't want judges to go beyond the evidentiary record. Because if you allow judges to go beyond the evidentiary record in those cases on the theory that judges should be looking at the broader social perspective, there's a danger that individual prejudices would affect the outcome. Therefore, particularly in the context of the administration of criminal jurisprudence, whether an accused is guilty of the crime which he or she is alleged to have committed on that particular day or over a series of transactions, that has to be decided on the basis of the evidentiary record, because that's the only guarantee that the time-tested evidence tested on the anvil of cross-examination by the application of a judicial mind to the record brings about an outcome. And that is the reason why, interestingly, we discarded the jury system in India in the 1950s after the Nanavati trial, the famous Nanavati trial, and did not opt for jury trials. If you ask somebody who is trained in US law, they would find it just incongruous that you don't have jury trials in India. But the reason why we abolished jury trials in India was to eliminate the need for popular prejudice in the decision-making in criminal cases. But having said that, to the first part of your question, there are obviously cases where you have to look beyond what really emerges on the raw print of the paper book, particularly when you are dealing with constitutional issues involving human rights questions. For instance, when we dealt with the issue of decriminalizing homosexuality, obviously the material which the court has to deal with has to go beyond the purely legal material which emerges from the facts of the case. You have to look at historical material, you have to look at sociological material, we are engaging with fundamental issues of policy. For instance, one of the cases which I've been dealing with, which was before me just last week, was should the government of India have a different policy in dealing with cases involving ASD, autism spectrum disorders, and what should be the nature of those policies? Now, obviously, in dealing with these sort of cases where you're engaging with the government, you're not dealing with pure law in that sense. The law is given to you by the Rights of Persons with Disabilities Act of 2016. But beyond broad principles like the principle of accommodation, reasonable accommodation, the law will not give you a solution unless you look at everything from the medical to the social to the psychological to the historical aspects of how these issues are dealt with. So depending on which end of the spectrum you are, and though judges may not like to confess this, but I can tell you that in so many of the cases which we deal with, we're actually at the cutting edge of law and policy. We always try, as judges, we always try not to transgress into policy. But so very often you're not framing policy, but you're pushing the policy makers to take a considered decision on matters of policy. But even to push policy makers to take decisions on areas which they have not taken decisions on, you have to understand what the ramifications of the policy are as a judge. And to understand the ramifications of the policy, you have to obviously look beyond just what is legal or what is the four corners of the statute.
Thank you. We conclude this this morning, with Professor Nigam offering some words of acknowledgement and thanks.
Thank you, Honorable the Chief Justice of India, Dr. D.Y. Chandrachud, Honorable Chief Justice of the Karnataka High Court, Justice N.V. Anjaria, esteemed High Court judges, distinguished guests, ladies and gentlemen. On behalf of NLSIU and our co-organizers of the 11th Annual Conference of the Berkeley Center for Comparative Equality and Anti-Discrimination Law, I would like to express my sincere gratitude to the Chief Justice of India for his keynote address. One of the objectives of this conference is to spread awareness about the constitutional values of equality and its importance to our democracy in an increasingly unequal and swiftly changing world. We are immensely grateful to the Chief Justice for underlining the range and application of equality considerations and laying out a vision of equality, especially the institutional, the design perspective that he brought out in his talk, and the connections between institutional design and equality, which was at once powerful, attractive, and compelling. I would like to thank the organizing team of the conference and the Bangalore International Center for all the hard work that has gone into the management of this event. We also had a number of student volunteers from the university. Their energy and enthusiasm have made this event that much more memorable. I would like to thank all the distinguished persons who have graced us with their presence today. We have among us today several honorable judges of the High Court, senior advocates, eminent academics, and senior officials from the government. Your presence has added value and prestige to this event and has shown your commitment and respect for the Constitution and the judiciary. NLSIU has a rich legacy of teaching and scholarship in constitutional law and administrative law. And in the backdrop of this conference and its emphasis on global equality scholarship, we are hopeful that the Honorable Chief Justice's talk will inspire a new generation of scholars and scholarship and ensure that equality continues to be at the forefront of our discussions in public law. Thank you all.